Hello everyone and good afternoon. Welcome to our LexisNexis Singapore live chat series. My name is Shali. I'm a practice area lead. I'm responsible for content commissioning and acquisitions. So this is our second COVID-19 special, and today we're very honored to have a special guest who will be speaking with us on employer obligations and potential issues that may arise from this COVID-19 pandemic. So we have a Q&A session at the end of this live chat. You can submit questions that you want to ask, and we will go through those questions. And you can submit them by clicking on the Q&A button at the bottom of your screen. Okay, so please welcome our guest, Mr. Thomas Choo. He is a partner at Clyde Co Clasis Singapore. So Thomas leads the employment and immigration practice in Singapore, and he has also written on a number of topics for us for our Lexis Advanced Practical Guidance platform. So Thomas, hi, welcome, and thanks for joining us here today. Hi, could you share with us a bit about the work that you do at Clyde Co?
Well, thanks for inviting me, Shali. I'm a corporate and employment lawyer at Clyde Co Singapore, as you have said, and head up the employment and immigration practice. We actually cover both contentious and non-contentious work in this practice. For the non-contentious work, we help apply for work passes for clients, in particular preparing the appeals if rejected. We help review employment contracts and handbooks. We advise on things like restrictive covenants, and we help clients navigate the legal risks of legislation and regulation, for example, the Employment Act and the never-ending MOM guidelines and advisories.
Right.
The second part of the practice is definitely the contentious side, where we help both employers and employees from the smaller things like prepping clients for TAFEP and MOM interviews and investigations. We help clients prepare materials for hearing at the Employment Claims Tribunal, to the bigger, obviously high-profile litigation and arbitration matters.
Well, it's great to have you here today, Thomas. So the COVID-19 pandemic has really made a huge impact on the global economy, right? I mean, in Singapore, MAS has already reported that this year we will be going into a recession. And unfortunately, it's going to be the worst recession since the 1998 Asian financial crisis, right? I mean, it's also expected that there will be job losses, lower wages, and also unemployment rate is going to go up. I mean, with such a bleak economic outlook, right? And a lot of companies and employers, they will be looking at cost-cutting measures to manage their manpower. But before employers actually consider layoffs, could you share with us what other measures and options that they can consider, and also what are those legal considerations that they have to be aware of?
Yeah, of course. I mean, everyone knows that there have been very strong statements issued by the MOM in recent weeks that employers should consider alternatives to redundancy and retrenchment. And I mean, I would say this is primarily because there has been quite a number of subsidies that they're granting to employers, especially the last couple of months. In terms of what measures can be adopted, it shouldn't be too different to other countries. But the Singapore government has encouraged a fairly robust process to be carried out by employers before actually going through a redundancy process. Firstly, employers are encouraged to make adjustments to work arrangements without wage cuts. This can take the form of sending employees for training, as an example, to upgrade skills, redeploying employees to alternative areas of work within the company, or implementing a flexible work schedule or a shorter work week. As an example, an employee could have his working hours reduced one week and then increased the following week.
Right.
Then if these adjustments can't actually be made, or it's not sufficient enough for the employer to cope with the outbreak, then the employer could consider wage cuts. Now, there are a few ways the employers could consider. Firstly, they could implement other work arrangements, for example, part-time work and sharing of jobs. They could also implement a shorter work week. They could also furlough or temporarily lay off the employees. I will talk a bit more about this now, as it is actually something new in Singapore. You hear a lot about this from the US and the UK, from the media in recent months, I imagine. Singapore didn't originally have this concept. And it was actually only provided as an option a few weeks ago by the MOM on their website.
Right.
I personally think that this is only a temporary option, and once the outbreak's under control, this option will be removed. But whether it's a shorter work week or a temporary layoff, there will be some criteria to follow if the employer wants to implement them.
Okay.
Another way to consider wage cut is obviously the usual way, to make direct adjustment to salary. In some organizations, there are what we call variable bonus payments, monthly variable components, annual wage supplements.
Yep.
The employers are encouraged to consider adjusting these first before the fixed monthly salary. Now, after all these have been considered by the employer, then the employer can start to consider extreme measures. No pay leave is one of them, but the MOM has actually advised that before you consider any of these extreme measures,
yep,
senior management should actually lead by example by cutting their own salary. Now, if all these measures don't actually help the employer at all, or it's not enough, then only at that point in time should employers consider redundancy. Do note, obviously, that there are procedures for redundancies, which I can probably go on for another hour and that can be another time.
Yeah. Okay, so so it sounds like there are quite a number of measures and options that employers can consider, right, Thomas? So we were going to deep dive into some of these. Just now you mentioned there are some criteria when it comes to implementing shorter work week, furloughing or temporary layoffs. Could you share a bit more about what those criteria would be?
Yeah, currently for shorter work week, there are 3 criteria for this. The first one is to make sure that it does not exceed 3 days in a week and does not last for more than 3 months at any one instance. The employers can also request employees to take up to 50% of their earned annual leave, and they must pay the employees not less than 50% of their salary on those days when they're not working. For the furloughing option, the temporary layoff, it is pretty similar to the shorter work week in terms of the annual leave request and the salary reduction. But in terms of the duration, the layoff period should not exceed 1 month at any one instance, again, subject to periodic review.
Okay, so going back to your point about the direct adjustment to wages, right? So you mentioned about adjusting down the variable bonus, the MBC, the monthly variable component, and the AWS, right? But what if these are not covered in the current employment contract?
The implementation of these measures are typically not by law, but more from, so it's more contractual.
Right.
It is not common for Singapore employment contracts to expressly provide for these measures. And as such, the rule of thumb is generally consent from employees will be required. Having said that, we are starting to get a little bit busy helping clients amend their template employment agreements to cover some of these scenarios, both for existing employees and new hires. And obviously, once amended, future consent from employees will not be required.
Right.
Additionally, if there is a trade union involved, the employer should review the collective bargaining agreement and see if there's a need to consult the trade union before implementing these measures. Chances are there will be a need.
Right. Okay. So talking about those measures that will involve wage cuts, right? And we know that foreign employees on employment passes, that there is that salary requirement by MOM, right? I mean, if employees are considered those measures that will involve wage cut, right? How will this then affect the considerations by MOM when it comes to renewal or approval of EP?
This is probably a tricky one. There was a change in MOM's stance during the circuit breaker period. The original and the typical position is that any lowering of salary of a work pass holder, for example, the EP holder, would require to be notified to the MOM before you do it.
Right.
Now, although MOM says notified, it is actually akin to an approval because, I mean, as everyone knows, EP holders and work pass holders have a minimum salary eligibility criteria. Now, interestingly enough, about halfway through the circuit breaker period, and I think it could be because of the overwhelming number of notifications by employers for this, the MOM actually announced that only certain categories of employers would need to notify it if they want to temporarily reduce the salary as a cost-saving measure in view of the virus. So what does this mean? Basically, if your foreign employee's salary is being reduced and his EP is up for renewal soon, what you should do is just check the online self-assessment tool, which is on the MOM website, as to whether he or she will still qualify for that work pass based on the lower salary. Now, if he or she does, then obviously no problem with the renewal. But if he or she doesn't, then it is likely that your renewal will be automatically rejected when renewing, which will then mean that the employer should submit an appeal to the MOM. And there will be things that you can obviously write in the appeal. You know, for example, you can say, oh, just a temporary measure and things like that. This is more on a case-by-case basis.
Right.
Now, for new work passes, I personally don't think an employer should bother at all applying during this period. From recent experience, there seems to be an automatic rejection of all work passes being applied for, which will then force employers to appeal by default.
Right.
We've actually been quite busy helping clients during this period at the appeal stage. And while the success of the appeal seems to be okay, seems to be pretty good, I always first ask the employer whether it's an absolute necessity for you to get this foreign employee abroad to come into Singapore during this period. And most of the time when you discuss with them, it's actually not necessary. But obviously, again, this is more on a case-by-case basis.
Right. Okay. Well, let's talk about beyond circuit breaker, right? I mean, we are about 2 weeks away from the end of this extended circuit breaker that will be lifted on the 1st of June. I mean, hopefully.
Hopefully it'll get extended.
Yes, hopefully, fingers crossed, right? So we know that there will be the safe distancing measures that will still be in place, right? But could you share with us what are the other things or employers need to take note of in terms of preparing the employees to go back to work?
The plus side is the MOM actually just released an advisory over the weekend, which actually was updated a couple of days back, called the, I think I get it right, Requirements for Safe Management Measures at the Workplace After the Circuit Breaker Period.
Right.
Now, it is pretty self-explanatory and extremely detailed. So I would actually encourage everyone, especially for HR, to read it for starters. In essence, though, there is nothing surprising, as most of these measures are quite logical, and most of the things we have been actually doing during the circuit breaker period anyway. But in summary, there are about 6 broad categories. The first is implementing a system of safe management measures at the workplace. The second is reducing physical interaction and ensuring safe distancing at workplaces. Again, nothing surprising. Third one, supporting contact tracing requirements. And then you have the more interesting ones, have personal protective equipment in place and get employees to observe good personal hygiene. You obviously must also ensure cleanliness of the workplace premises. And last but not least, implement health checks and protocols to manage potential and confirmed cases. I would actually add that based on my reading, there are a couple of new things. The first is the wearing of masks at workplaces, which will be interesting for everyone, especially those in offices. There are some exceptions. For example, if you're eating, understandably, I guess, or you're doing a work activity that requires masks to be removed, but very limited exceptions. And the second is something that seems to be brought to everyone's attention nowadays, the Safe Entry Visitor Management System. Offices would need to use that to basically record the entry of all personnel, including employees and visitors entering the workplace.
Right. Okay. So talking about returning to the workplace, right? I mean, Facebook and Google, they announced just last week that they will allow all their employees to work from home till the end of this year. Now, obviously, not every company will have that kind of technological means, or because of business needs, will be able to have that kind of measure for all their employees. I mean, what can employer do in the situation if some of the employees may not feel comfortable to return to the workplace? I mean, this can be because of personal health or family situation. And also, what can employers do if employees, some of them may not feel comfortable or they're nervous about traveling for work, for business trip overseas. And this can be even after the travel bans have been lifted. What would be your advice for employers in that kind of situation?
I personally think that there's a delicate balance here. On the one hand, employees are contractually obliged to attend work pursuant to the terms of his or her employment contract. I think everyone's aware of that. But on the other hand, again, employers have this obligation under the Workplace Safety and Health Act that they need to take measures as far as reasonably practicable to ensure the safety and health of the employees at work. Now, the latest MOM advisory is also quite clear on the safety and health aspects. It's made very clear again that where employees can perform their work by telecommuting from home, the employer must ensure that they do so.
Right.
Obviously, there are job roles or functions where employees cannot work from home. I mean, frontline operations is an example. The employer actually should ask the employees and understand from them why they're not comfortable and whether such concerns are legitimate, and if so, to address it. Now, as an example, very early on before the circuit breaker period, we had a client whose receptionist wasn't comfortable being at the reception. As she felt very exposed, and refused to go to work.
Yeah.
And the employer basically wanted to know legally what they can do. Now, at that time, if you remember, there were no requirements to wear a mask. But logically, when I explored the position with the client, it made sense for her to feel unsafe at work. And we basically advised the client to start accelerating the implementation of their workplace safety measures. They actually had a policy on that. Now, so once the employer managed to procure the masks and sanitizers for starters, and for this individual specifically, they actually got her that full-blown mask with a plastic shield. She was actually fine with it, and then started to come to work again. Right. So at the end of the day, employers should consider in advance how they will deal with these situations. If their preference is not to agree to such requests, then they should have valid reasons. They should have a proper rationale as to why employees will have to go into the office.
Okay.
The second part of the question,
traveling, yeah.
Now, in terms of business travel, I think there must be a very, very good reason why the employee has to travel for work. As from a legal standpoint, it's actually a little bit difficult, currently anyway, for an employer to prove that business travel is more critical than the health and safety of an employee. I mean, even if the travel ban has been lifted, it's not a matter of just taking precautions and hoping the employee doesn't go get the virus. But there's so many other things to consider. I mean, you have the stay-home notice, you have the quarantine periods that all countries are enforcing, even when you arrive at the location. There's insurance claims coverage, etc. There are many things for the employer to consider. So I think if an employer actually wants an employee to travel, for starters, there has to be some extensive research done on the two countries in question. In particular, whether there are any potential health and safety concerns for the entire journey. That is from the time the employee leaves his or her home, go to the airport, board the plane, during the flight, the accommodation venue, the location of the meetings there, all the way back to his or her home. And because of these concerns, I actually wouldn't encourage an employer to force employees to travel for work during the period anyway.
Yeah, sounds like it's really, not advisable, right? And also in terms of the workplace safety you mentioned, so other than taking that necessary precautions, it's also very important to communicate and also to assure employees that, necessary precautions and measures are being taken and their well-being is of priority to the employer, right? So, this whole pandemic has really changed, the landscape of how we work and how we do business, right? I mean, Thomas, nowadays, when people talk about BAU doesn't stand for business as usual anymore. BAU stands for business as unusual, right? I mean, how do you think this will change, from the perspective of employment? Like, what do you think will be the future trends, because of this?
I mean, it's a big cliche, but like what you said, I don't think things will be the same again. And we welcome the new normal. I see a few main trends based on the advice that I've been starting to give more recently. Firstly, I personally think that there will be an uptrend claim by employees for injuries at home. Now, it's very likely that there will be more employees working from home going forward. I remember there was a local survey done recently where I think 80% of employees want to continue working from home. But interestingly, quite a number of those employees also felt that it was less productive to work from home. I mean, poor employers, right? But now the question is whether your own home is considered a workplace. And if so, what happens if you injure yourself at home? Does it actually fall under the Workplace Safety and Health Act? Probably so, because workplace is actually defined very broadly in the Act itself. But it may be sometimes harder to prove that it's because of work that you had that particular injury. I personally think that we would expect the MOM advisory on this going forward. Now, secondly, as a result of more employees working from home, I won't be surprised if most, if not all, employers are looking to cut office space and reduce costs in terms of rental. What does that mean for employees? Now, obviously, more redundancies, and linked with that, more unfair dismissal claims. Good work for the lawyers, obviously, but not so good for the employees and employees. Now, for the employers, they will be looking real hard at whether those people that are working from home are replaceable, and therefore we may see an uptick of redundancies. From the employee's perspective, there could be an uptick of unfair dismissal claims for what I like to term disguised redundancies, which is basically termination of employment, which is actually redundancy, but disguises others. For example, misconduct or poor performance. I've been doing a lot of this recently.
So it's without the redundancy package included in those situations?
Yeah, in those situations, employers would not want to go through the hassle of a redundancy process as per MOM guidelines and the statutory process for that. They would just want to chop the employees almost immediately. And usually, misconduct or poor performance, you obviously still have a process to follow. But like you said, the redundancy payment is something that they probably look at, especially for an employee that has worked for quite a number of years with the same employer. Now, there may also be a new category of unfair dismissal claims, mental health. I've seen a few very recently where an employer terminates the employment of an employee without reason, because that's again permitted by the MOM. But the foreign employee actually came back with an alleged unfair dismissal claim, specifically discrimination by way of mental illness. Now, there are two camps for this. On the one hand, people who say that they are more than happy to work from home. And therefore, you would say they have more work-life balance, and that means a reduction in stress levels, improvement of mental well-being. Now, the other camp is those that prefer to be in the office, where everything works like clockwork. And being forced to work at home actually increases stress levels. I personally fall under this category, the second category. Okay? For starters, you lose track of time, you lose track of days, and you tend to work longer hours subconsciously. As an example, I didn't realize there was a public holiday last week, and until a client actually asked me why I wanted to fix a call on a public holiday, And just an additional tip, not many people actually know that mental health is considered an illness under the Workplace Safety and Health Act, and is therefore a claimable injury. Most, actually, if not all, of recent mental health claims under the Workplace Safety and Health Act is actually related to post-traumatic stress disorder. Now, another trend I see is increase in termination of employment, specifically as a result of doxing and breach of confidential information. Now, for doxing, for those of you that don't know what it is, it's actually an offense under the Protection from Harassment Act. And it is basically publicizing the identity information of someone in order to harass, threaten, or facilitate violence against that particular person. We see that all the time now. When someone reaches minimum order, suddenly, everyone starts to forward messages left, right, center, just that person, things like that. That's actually doxing. So employees will need to be mindful not to recklessly share and forward these images and these personal information to friends and colleagues. Breach of confidential information is probably the more important one. Now, why do I say this? Now, you're stuck at home with family members and loved ones. If you work from home, you will be at home. What happens if you're in a smallish unit and one of your family members or loved ones work for a competitor? You may also have printouts scattered over your home. You may be making confidential calls. Your laptop may not be locked at home. But what happens if you're working, let's say, on a confidential business transaction, and it actually got leaked by one of your family members or loved ones to a friend? Or one of them actually was a listed company and actually bought shares in it. Insider trading come into play.
Right.
You may also be unlawfully downloading your employer's confidential information. If you're thinking of leaving the company, client lists, etc. It is now made much easier because you're at home.
Yeah.
So from an employer's perspective, there's a huge, huge legal risk that they will need to be aware of before actually blessing someone from working from home. I'll just talk one more very quickly that just came up from the top of my head. Active enforcement by the MOM. Now, we all know about the MOM guidelines not being legally binding, but guidelines which are persuasive, interpreted by the courts, encouraged to be complied with by employers. You see nowadays the MOM has taken it one step further by actively publicizing all their enforcement cases through media.
Yep.
We've all heard about employers being suspended of work pass privileges, Singapore citizens' passports being cancelled, PRs, work pass holders having their re-entry permits and work passes revoked, all barred from entering Singapore. So we may expect more of this, and also I think for some of these guidelines or advisories which are non-binding to be actually enacted and cast in stone in legislation, which would then give MOM more statutory power.
Right.
Hopefully that will give you a flavor of the trend I can think of.
Okay. Well, unfortunately, we would love to, pick your brains on that, actually about the future trends, Thomas, but I think we are running slightly out of time. So let's jump into our Q&A section. I think we have 2 questions received already.
Okay, let me have a look. The first one, do you anticipate many MNCs having to lay off or retrench foreign employees? Well, the answer is yes. Like I said just now, a couple of things. The first one, right now, you see even statistics from the MOM, and they tend to share it on a periodic basis. The trend has been ticking upwards already. I think they're expecting about 40 or 50,000 of retrenchments to be made by the end of this quarter. So definitely an uptick, and not even now. I expect the retrenchment to kick on as a further trend also. The issue with this particular outbreak right now is we don't know when it's going to end. There's that uncertainty. Yeah. If you read the news, companies are preparing vaccines and everything, but the earliest vaccine that's available is end of the year at the very earliest. Okay, and right now what's happening? You have countries out there all starting to open not about their borders, but open the economies again.
Yeah.
Easing all the measures. I mean, UK was the most recent one, US.
Yeah.
Now, things are not under control there, yet. But because of economic issues, they have actually accelerated easing the measures. And for those countries, I mean, touch wood, doesn't happen, but it's very likely that there'll be a second wave, and very likely again that they will be forced to close again.
Right.
So there's that uncertainty there until the vaccine comes into play.
Right. I think we have time for maybe one more question.
Sure. Okay, there's quite a few also, so let me just go through. Just give me a second. This one will be an interesting one. I mentioned amending contract templates to provide a contractual mechanism for unilateral changes to salary terms and presumably extending work hours of a contract. Yep. Is there any concern or issues that such a contractual mechanism will be deemed an unfair term? So in summary, I spoke just now about amending employment contract templates to cover for some of these scenarios so that you don't need to get employee consent in future. Now the question is, will this be considered unfair going forward if the employee agrees up front? Now, that's a good question. And at the end of the day, it's a balanced approach. It's what I like to call reasonableness. You can't obviously put in something to say that we will cut your salary 100% at our own discretion when we feel like it. That's the extreme, which obviously is a big no-no, and it's what we call the repudiatory breach of the contract. But there are limits that you can do that is more reasonable. For example, if certain conditions or events happen, as an example, this particular virus, then, or revenue of the company falls below a certain amount, then you agree that we will reduce your employee your salary temporarily for perhaps 1 month or 2 months and revisit it. It's very helpful, obviously, that the MOM comes out with all these advisories like the following temporary layoff. So from the lawyer's perspective, we can sort of gauge what the MOM feels is fair and reasonable. Yeah. And we'll tend to use all these and basically incorporate all this and consolidate all this into that contract itself, or into that clause itself.
All right. Okay. Well, unfortunately, I think, because of the time constraint, we won't be able to take all the questions. But this has really been a very informative chat, Thomas. So thank you again for sharing your valuable perspectives on these very pressing employment matters. And to all our attendees, thank you for taking the time to join us here today, and also for submitting all your questions. I hope we have addressed some of your concerns or issues. But if you do have any further questions or you would like legal advice from Thomas, you can get in touch with him directly at thomas.choo@clydeco.com. And if you would like to contribute to our LexisNexis COVID-19 Resource Hub, or you'll be interested to be a special guest for our next live chat session, you can get in touch with us at write@lexisnexis.com. That is WRITE@lexisnexis.com. So in the meantime, stay tuned as we will have more sessions coming up. And until then, take care, stay well, and goodbye. Bye.
Thanks, Shirley. Bye-bye.
Bye. Thanks, Thomas.